Welcome to Court Helicopter Explainer over the week. As you know, we deal with the topical issues ranging over the week. We have seen the Raphael Tuju, Dari Business Park drama. We have seen it take a serious political angle. Tuju is arguing that somebody very powerful wanted his property, he refused. We have seen the drama of the police coming at 3 a.m. to evict Tuju. We have seen politicians from the Luo community gang up to support Tuju. We have seen Tuju write a letter to the Chief Justice to intervene. People are talking about several cases that Tuju filed in the Kenyan courts. Court Helicopter brings to you the real law behind all this. The law that deals with this matter is a law called Cap 43, what is called the Foreign Judgments and Reciprocal Enforcement Act. You know, people think that Kenya doesn't have laws. We have laws. And today we are looking at the Foreign Judgments Reciprocal Enforcement Act, Cap 43. What does the law say about the Tuju issue? Facts of this matter is that Raphael Tuju, when he was a member of parliament for Arienda, entered into a loan facility agreement with the East African Development Bank. In that agreement, the law that was going to be applicable was the British law. So the agreement for the loan was very clear. It excluded Kenyan courts if a dispute arises. Honorable Tuju was given money. He defaulted to pay. The case went to a UK court because the UK court is the one that had jurisdiction. In the UK court, Tuju defended himself. The case proceeded. Tuju lost. When Tuju lost, the bank came to Kenya pursuant to this law we are saying, the Foreign Judgment Reciprocal Enforcement Act, to enforce the judgment of UK. Why? The property that the bank funded was a property in Kenya. The subject matter, that is the Dari Business Park, is a property outside the jurisdiction of UK. So under this law, once you have gotten judgment from a different jurisdiction, so long as it's a Commonwealth country, that judgment must be brought to the High Court of Kenya under this act. And therefore, these are the steps from UK to Kenya. The first step, after the judgment was issued in that country, they took the next flight to Nairobi with the judgment. And after they landed in Nairobi, they went pursuant to Section 3 of this act and went and made an application to the High Court of Kenya. After they made this, their argument is that the judgment is a judgment known by the Kenyan court because there is a law called the Foreign Judgment Reciprocal Enforcement Act. So they went for what is called a court with jurisdiction. There are two jurisdictions here. The first jurisdiction under Section 4 is the jurisdiction where the dispute is going to be resolved. That is the UK court. The second jurisdiction is the jurisdiction where the property is, and that is why they never went to Uganda High Court, they never went to Tanzania High Court, they came to Kenyan High Court. So, after they came to Kenya High Court, they produced in 4C an agreement that was signed by Tuju, saying that the jurisdiction of the British court was allowed. The court also looked at the proceedings and found out that Tuju appeared before the court. 3, the High Court in Nairobi looked whether Tuju contested the jurisdiction of the UK court. At the UK court, Tuju never contested the jurisdiction of the court in the UK. 3, they also looked whether there is an appeal. They found out that there is no appeal proceeding in the UK court, and therefore the application was allowed, and they were told now to register under Section 5. You do a registration of that judgment. That judgment of American court was allowed to be registered. After it had been registered in the High Court, it now becomes a matter for determination before the High Court of Kenya, because the registration has been done. After the registration, what is the effect of registration of a judgment? And here is where I want Kenyans to understand. Subject to this act, a registered judgment shall, for the purpose of execution, be of the same force and effect as a judgment of the High Court entered at the date of registration. That judgment from the UK, once it was registered in Kenya, it became a judgment of Kenya High Court. It stopped being a judgment of the UK. That judgment, it is a judgment for the purpose of execution. Execution means enforcement and bringing to the fruits the favors the judgment person has. That is to sell the properties of Tuju for the bank to realize its money that it gave it. So once that judgment has been registered, Tuju had a right under Section 8 to apply for stay of execution of that judgment. What does it say? Unless the High Court otherwise orders, execution upon a registered judgment shall be stayed. So Tuju applied for stay, and the judge and the court allowed for stay so that Tuju can argue his case. Tuju filed a matter under Section 10 of the Foreign Judgments Act to setting aside the judgment on grounds that the judgment was obtained in the UK by fraud and misrepresentation. This was hard, and the judges stopped execution until the application to set aside pursuant to Section 11 was heard. When this was heard, the court has a duty to set aside any judgment if it finds that that judgment does not meet the following criteria. Section 10, what are the grounds that the court looked at, and what does the ground look? Section 10(2) says the grounds upon which a registered judgment may be set aside are: 1, if the judgment is not a judgment to which this act applies. For example, if you bring your judgment from the forest, you bring it to court, it will not be allowed. If the judgment is not a judgment that can be known, for example, a judgment from a banana country, which is not a Commonwealth country, a judgment where we don't have a reciprocal agreement with that country. Tuju's judgment was found to be a judgment for the purpose of this act. 2, the judgment was registered in contravention of this act. Was the judgment properly registered in the High Court of Kenya? Yes, Tuju failed there. 3rd, the courts of the country of original court had no jurisdiction to adjudicate upon the course of action. Did the court in UK have jurisdiction? Tuju said it didn't have. The learned judges found out that the court in UK had jurisdiction because 1, Tuju never contested the jurisdiction in the UK. 2, he appeared and filed documents. 3, he had lawyers who represented him. 4th, the contract of the agreement for the release of the money expressly provided for that the jurisdiction of the court was going to be in the UK. So Tuju lost on that ground. 4, the judgment debtor did not appear in the original court and the jurisdiction of that court was based on an agreement. Did Tuju appear? If he did not appear in the UK, the Kenyan court could have dismissed that judgment. Tuju appeared. 5, the course of action upon which the judgment was given. The course of action, when you talk about the course of action, is where did this thing happen? The transactions were done in UK. The disbursements of money was done from UK. The agreements were done in the UK. And therefore, the Nairobi High Court found out that it cannot set aside Tuju's argument that it was fraudulently obtained. F, the court looked if the judgment of a court in Kenya which is irreconcilable with the judgment of the original court. The judgment of America, the question is, courts will look at, is this judgment from UK similar to if this matter was filed here? Could we in Kenya, a judge in the High Court of Kenya, make the same judgment based with the same facts? The court in Nairobi looked at the judgment and found it is a fair judgment. It is not a judgment that does not conform to the international law, and if the case of EDB Bank was brought to Nairobi, the Nairobi High Court could have reached at that time. G, the court looked at if the judgment debtor, that is Tuju, being the defendant in the original proceedings, 1, was he not duly served with the process of the original court? Courts are very critical. If there is no service, then the judgment will be set aside. There was evidence that Tuju was served. There was a document called affidavit of service. Tuju appeared. He filed a memorandum of appearance. He filed his defense. He filed his pleadings. He argued and he lost. Out of that, the Nairobi High Court said they cannot set aside the judgment. The second thing they looked at is whether Tuju received notices of the proceedings in sufficient time to prepare and appear. The notices normally are 14 days, 7 days, 21 days, 30 days. Did Tuju get these notices? Yes. Did he appear? Yes. Did he challenge or did he bring it in the UK that the notices either were served on an email that was not Tuju's or the lawyer's law firm? He did not. Did he contest that the notices and summons to appear in court were the duration was short? He did not. So the High Court found out that Tuju was served properly. The third criteria is whether he appeared by himself or he appeared by representation. The court found out that Tuju appeared, filed documents, signed affidavits, his lawyers appeared in court, and he never contested. He never contested in the UK. H, Was the judgment in the UK obtained by fraud? Other than fraud? So the question before the judges in Nairobi was that, was this judgment obtained by fraud? Because if the judgment in the UK was obtained by fraud, the Kenyan High Court has jurisdiction to dismiss and set aside that judgment. The Kenyan court looked at it and were convinced that there was no fraud. That the burden of proof when you allege that there was fraud, it is the one who alleges, it is Tuju who had to bring evidence to show that there was fraud in the UK. He lost on that ground. The judges also looked at there are provisions of the Kenyan law under what is called a private international law of Kenya. Was this law contravened? The law, what is called the private international law of Kenya, was not contravened. Therefore, the judges in Kenya found it stood. Then we have J, what they say under this section 3.3, is the decision of the UK going to be different from the decision if it was in Kenya? They found out that the High Court in Kenya, if it is the one who faced that decision, it could have agreed on time. K, the judges in Kenya looked whether there is an appeal that reversed the original decision. Tuju lost the case in the first court. He came to Kenya. He could have filed an appeal to set aside that judgment. Remember, we have in Kenya 4 layers: the Magistrates Court, the High Court, the Court of Appeal, and the Supreme Court. Did Tuju go to a higher court in UK? He never went to the higher court. He came back to Kenya to challenge instead of going to a higher court. And lastly, N, the enforcement of the judgment could be manifestly contrary to the public policy in Kenya. We have what is called the public policy in Kenya. Is this judgment going to affect the public? No. This is a contract between a bank and a citizen of the republic. That is a customer and a bank. The courts looked at it and found out that it does not offend the public policy of Kenya. Based on that, they looked at the appeals under section 11. Is there an appeal? There was no appeal available pending. Lastly, what is the effect of setting aside of this judgment? Had the judges set aside the judgment, then Tuju could have been saved. Issues. Can the CJ intervene on the judges to listen to this matter? Under the Kenyan law, the CJ has no power to interfere with the independence of the decision making of judges. What will happen to Tuju? The bank will auction the property, and the bank operates under what is called, they have the statutory power of redemption. What we mean, if a bank gives you a loan, you have entered into that agreement, you must pay. Dawa ya loan ya bank ni kulipa. So that is the fact. If Tuju had this option, he could have entered what we call an agreement with the bank, what is normally called a private treaty, so that he is allowed to sell. Then he pays back. He did not do that. It is sad, it is unfortunate, but Court Helicopter News will never fail to bring you the law as it is. We wish all the people to understand that the moment you take a bank loan, dawa yake ni kulipa. Wakili Danstan Omari.